Yo, what's poppin', people? Your boy Snacks is back in the building with another banger. And you know how we do before we get started. You know what to do for your boy. Hit that like button, hit that subscribe button, and don't forget to turn your post notification bell on so you'll know when your boy is going live or dropping this heat. And it's a Saturday, a beautiful Saturday. And today is hot as hell in Texas. And I'm dropping this video real quick because I'm getting ready to go out to the Juneteenth celebration, picnic, party, concerts. My boy Paul Wall and a host of others. And it's a free concert for us here in the city that I live in Texas. So I hope everybody else had a wonderful weekend. But before I go, we want to drop this update on Shiloh's case. Since I started covering it, I got to finish covering it. And the update dropped this morning on USA Today, and we're going to get into it. Let's go. Oh, update on Shiloh's case in his bankruptcy case in the USA Today. Dropped an article this morning, and y'all will see me looking up because that's where my second monitor is. So don't pay me no attention. But let's get into it. Judge issues a ruling in bankruptcy case of Deion Sanders' son Shiloh, and it reads: a federal judge has issued a ruling in the bankruptcy case of Colorado football defensive back Shiloh Sanders, denying Sanders' attempt to dismiss a complaint from a former school security guard whom Sanders still owes $11 million. That's a lot of money. Shiloh got 11 million, but you know. And it states the security guard John Darjean had filed a complaint against Sanders in January to prevent the bankruptcy court from discharging the $11 million debt. Sanders' attorney then asked the judge to dismiss the complaint, calling it an overreaching, intimidating tactic filed with meritless allegations. But Judge Michael Romero didn't agree and has kept most of Darjean's claims alive, including allegations by Darjean about the limited liability companies owned by Sanders for his name, image, and likeness deals. So he kept some of the judgments and put threw some of them out. So Shiloh still has a chance, but he hasn't thrown the $11 million judgment out yet. So let's see. The complainant contains sufficient allegations that Sanders Company's functions as his alter ego and that the corporate veil of the LLCs should be pierced, Romero wrote in his ruling on Thursday. This is not good news for Sanders, 24, son of Colorado head coach Deion Sanders, but in the case far from over after he filed for bankruptcy in October in an effort to free himself from the oppressive burdens of his debts, as his attorney describes it. So now that Shiloh filed this, so some of his case can be heard since he didn't attend his initial court appearance and dude got this $11 million ruling, but simply because Shiloh wasn't in court. So the reason Shiloh filed for bankruptcy was for his case to be heard in front of a judge so they will know what to do, whether to throw the ruling out and put his $11 million in his bankruptcy filing or just keep it outside of his bankruptcy and say, hey, you got to pay this man. We're not going to put your $11 million in your bankruptcy file. But let's continue. What was the ruling about? Darjean wants to collect on that $11 million debt owed to him by Sanders. It stems from an incident in 2015 when Shiloh Sanders was 15 years old. Darjean, a former pro baseball player, was working as a security guard at his school in Dallas and trying to confiscate Sanders' phone when he said Sanders snapped and assaulted him, elbowing him in the chest and causing him permanent injuries. You let a 15-year-old bust your shit. and then you're gonna cry about it. Darjeem sued Shiloh Sanders in 2016, seeking damages to compensate for his injuries. To compensate for his injuries, my bad. The case then went on trial in 2022, but Sanders didn't show up for it, leading to a $11.89 million default judgment against Sanders for Darjeem to recover. Last October, Sanders filed for bankruptcy to get out of that debt. And now Darjeem is fighting this potential debt discharge in the bankruptcy court by making several arguments why it shouldn't be allowed. Hey, Shiloh saying, hey, this goes in my bankruptcy. Dude saying, no, that $11 million judgment is mine and mine alone. It shouldn't be included in his bankruptcy filing. So if Shiloh gets them to include his $11.89 million judgment in his bankruptcy, he won't owe that money. That money will go to bankruptcy court and it'll be paid out. If y'all know how bankruptcy works, it'll be paid, but it won't be that much. It won't be $11 million. It'll probably end up being like one or two, and it'll be paid out over time. It won't be a lump sum. But let's get back. One of those arguments was that Shiloh Sanders should not be allowed a discharge because he was using the LLCs to improperly conceal assets that instead should be a part of the bankruptcy estate to help pay back Darjeem under the law. Such actions could prevent the debtor from getting a discharge of his debt. His attorneys argued in the complaint that the lack of disclosure of the individual NIL interests of Shiloh and the sworn lack of any contact or transfers between Shiloh and his companies indicate that they are the alter ego of Shiloh Sanders and are shams which should be pierced by the bankruptcy trustee and or creditors. Why did the judge say that? The judge noted that one of the primary issues in this case is Sanders' treatment of his name, image, likeness rights as a college athlete. He also noted that Darjeem's attorney has alleged that Sanders wholly owns LLCs or his alter egos, excuse me, which corporate veil should be pierced. This means that they are alleging that the companies are basically shams used to shield his assets from liabilities and should be pierced to lift that shield. That is correct. It's not a sham. Everybody that owns a company does that. Nobody wants to be personally liable for what their company does. I'm not liable for what my LLCs do. Personally, that's the purpose of owning a company and an LLC and a corporation. So that if somebody sues the company, they don't sue you personally, or they sue you personally and the company is not liable. That's the purpose of the whole thing. So what is you talking about? The court is unwilling at this stage of the proceedings to rule out applications of alter ego or veil piercing doctrines. On this matter, the judge wrote, okay, so the judge right now is saying that, okay, right now we gonna leave this in here. But if you don't prove it, but now the burden is on dude to prove that Shiloh is using these companies as his alter ego instead of just using them as his companies like they should be. The judge also said Colorado law appears to generally recognize both alter egos and veil piercing, or more accurately, outside reverse piercing as legitimate remedies, such as reverse piercing allows creditors to collect assets from LLCs of a debtor. The court therefore denies Shiloh's request to dismiss Darjeem's claim purely on the basis that it might involve assets owned by Sanders LLCs, the judge wrote. However, the court cautions Darjeem that reverse piercing is considered an extraordinary remedy, and he faces a high burden to demonstrate all the necessary factors at trial. Now, that's where he might lose at. Because now you, like I said, now you got to prove it. You just can't say, hey, judge, this is what's going on. You got to prove that this is exactly what he's been doing. And he only did it for this purpose. So Shiloh has probably had those LLCs for years, and they have just been sitting there. and they've been collecting money since he's been in college, and that's what he's been doing with his company. But we shall soon find out. So, what is next in Shiloh Sanders' bankruptcy case? Sanders' attorney previously said that the complainant at issue Thursday contained inaccurate statements and baseless claims in an attempt to prevent honest but unfortunate debtor from getting his fresh start at life. Yeah, see, that's the purpose. If he can't get a fresh start at life because he ain't got them 11 million. He want them 11 million so I can get my ball on, Judge. I got the ball out. The judge ruling means much of Dejon's case cleared an early hurdle and will proceed toward trial. Though the judge did not outright grant Sanders' request to dismiss one of the 5 counts alleged by Darjean, the judge otherwise denied Sanders' request or allowed Darjean to amend parts of his complaint to better plead his case. In January, Darjean filed a separate complaint seeking to prevent the debt discharge on the basis of the debt stems from a willful and malicious conduct as it relates to his injuries. The complaint also remains active and is arguably the biggest risk to Sanders' chance of discharging his debt. Look, man, this thing gonna take a while. It might take another year or so for this case to be completely finished because they still got a lot of stuff to go through. And ain't no telling how it's gonna turn out. But hopefully